Hello everyone, I'm Seth Weissman. Welcome to another episode of Practicing Safe Real Estate, and I hope you are all safe and healthy. Today we are going to address or try to answer the 5 hardest questions I've received about COVID-19. So let's get at it. Question number 1 is, what do you do if you're asked by your buyer client to do a final walkthrough because the buyer is either sick or sheltering in place? Should you do that final walkthrough for them? And the answer is no. It should be polite, but an absolute no. That is not something I can unfortunately do on your behalf. And the reason you should not do it is it opens you up to almost unlimited liability for any issues or problems with the house that were not repaired as they should have been. And we are currently defending a realtor who did a final walkthrough. She was there to look at certain roof repairs. They looked fine to her, but unfortunately they were not done correctly. The roof needed, as it turned out, to be replaced for some $15,000 after closing. And the buyer, who was up front so appreciative that she was willing to do the walkthrough, sued the real estate agent for the $15,000. That is why you do not want to take on this responsibility. Question number 2, is having your military transfer orders canceled to a Georgia base a coronavirus-related event, or CRE, entitling you to postpone the closing or to cancel the contract? This question has been asked a few times in relationship to the GAR COVID-19 special stipulation, and I can tell you this is not something that was contemplated by the GAR Forms Committee as being a CRE or COVID-related event. And my response would be, if your military orders are canceled and you can't close, then if that is the case, you're likely going to lose your earnest money as a member of our military. And just one other thought here, when you really think about the COVID-19 special stip of GAR, what it was trying to address are emergency types of situations where a buyer either has the disease or our courts are closed or the closing attorney or lender's offices are closed. That's really in a different category than having your military orders canceled. You can certainly argue that having your orders canceled is related to COVID, but it actually does not prevent you from going to the closing and closing on the house. You can still buy the house, you can rent it. But I personally do not think that is a COVID-related event, certainly as we intended it in the special stipulation. Question number 3, do I have to disclose that my sellers are healthcare workers to everyone coming to see the listing? My answer to that question is no. And the reason I say it is no is you can get COVID-19 anywhere you go. You can get it going to the supermarket, you can get it at the gasoline station. It is everywhere, unfortunately. And I think the real risk of getting COVID-19 is not related as much to where you work, but what you do to protect yourself. I don't think you need to make a special disclosure if they are healthcare workers. But here's what I would do. And I think this is a great idea for all listings. I would put a sign in the front door window that says something like, For your protection and for ours being the seller, we have provided you a courtesy pair of gloves in the main hallway coming into the house. Please wear them as you walk through the house for your protection and for ours. And what you're doing as a practical matter is you are then, in a real world way, mitigating the risk that anyone is going to get sick. The next question, what is force majeure and does it apply in Georgia? And force majeure is actually a French term. It means in English superior force. And what it is as a legal theory is that if there is an act of God that prevents parties from performing, then you are excused from performing until the act of God goes away. So for example, if there is a hurricane or a tornado and the town of Savannah is closed as a result of the hurricane, is that an act of God that would prevent you from going to the closing? The answer is yes. Is COVID-19 a force majeure event? It might be, but here's the important point. In Georgia, force majeure is only applicable if you have written into your contract a force majeure provision. The GAR purchase and sale agreement does not contain a force majeure provision. So while I've seen lots of buyers trying to get their money back, quoting force majeure is the reason I am not closing, it is really inapplicable whenever you are using a GAR contract. The final question is, how long of a financing contingency should you be including in your contract now that mortgage lenders are re-looking at your credit often a day or two before the closing? And we are seeing situations where buyers are losing their approvals and can't close because of a lender changing their mind on the loan. My suggestion is, if you can increase the length of the financing contingency, it's a great idea. Ideally, what you would want to do is have it run through the date of closing, would give your buyer maximum protection. But here's the rub. We did this back in 2008 when not many buyers were making offers on properties. Today, we still have very limited housing inventory. And if your buyer makes an offer with a very long financing contingency, and there are other offers on the property with a normal financing contingency, your buyer is really going to end up on the short end of the stick, and the seller's likely going to accept a different offer. So I think what you have to do as a buyer's agent is evaluate how likely it is that other offers are coming on the property before you decide whether to include a longer financing contingency or not. Well, that wraps up today's show, folks. I hope everyone stays safe, healthy, and most of all, informed. And look for other episodes. The next one we're doing is on what to do when you get a bad inspection report. Have a great day, everyone. Good to see you all virtually. Bye now.